We are moving on to the fun and exciting topic of client fund management. And Matthew Besser has agreed to talk to you about this topic. He is a principal at Bullock Besser Glacius. I should have asked about that name. LLC, where he focuses on representing individuals in employment discrimination and civil rights cases. He served as a law clerk to Judge Richard Nygaard on the United States Court of Appeals for the Third Circuit. He's a frequent speaker in the field of employment law. In 2014, he was named by Super Lawyers magazine to the Cleveland Super Lawyers list in the field of employment law, representing individuals. He was previously named by the publication to its Rising Stars list in employment law in both 2012 and 2013. And he's taught here at the law school in appellate advocacy. So thank you so much for coming today.
All right, I know that this is not the sexiest topic, but it is an important one. So we're going to talk about one of the best ways. I'm also on the grievance committee, the Bar Association grievance committee. So one of the best ways to get yourself in trouble at the committee is the mishandling of client funds. This will not be the most fun hour of your day. However, it might be the most important because the Supreme Court of Ohio has told us just how seriously they take this issue. In a 1982 case called Columbus Bar Association versus Thompson, the court said that the mishandling of client funds, either by way of conversion, commingling, or just poor management, encompasses an area of the gravest concern of this court. So conversion, stealing, commingling, mixing, or just poor management, being sloppy. And when the Supreme Court of Ohio uses words like grave, they don't use them lightly, especially when they're talking about attorney conduct. So that ought to set off some alarm bells about just how serious this admittedly somewhat dry topic is. All right. Fortunately, there is a golden rule, a North Star that can guide you when you are dealing with client fund issues. And the golden rule, the North Star, is this: do not commingle your funds with the funds of your client. Don't mix them, okay? If you can only remember one thing that I say today, it is that. Don't mix your funds with the funds of your client. A lawyer shall hold property of clients or third persons that is in the lawyer's possession in connection with a representation separate from the lawyer's own property. That's Rule of Professional Conduct 1.15a. 1.15 is the rule we're going to be talking about today. That's the commingling rule, your golden rule, your North Star. Again, the Supreme Court has told us it is of the utmost importance that attorneys maintain their personal and office accounts separate from their client accounts, and the violation of that rule warrants a substantial sanction whether or not the client has been harmed. Notice that language at the end. So, utmost importance and substantial sanction whether or not the client has been harmed. We're going to talk a little bit about what those sanctions tend to be, but that's our overarching rule, okay? If you have questions at any point, just jump in with them, okay? Just grab my eye or whatever. So, if we have to keep our client funds separate, where do we keep them? Funds, quote, shall be kept in a separate interest-bearing account in a financial institution authorized to do business in Ohio and maintained in the state where the lawyer's office is situated. Again, 1.15a, also revised code 4705.09. All this is in your materials. All right, that's where you keep your funds. You keep them in your IOLTA account. That's the acronym you need to remember. IOLTA stands for Interest on Lawyer's Trust Account. That's the separate bank account that you keep, where you keep your client's money in order to keep it separate from your money. The interest earned on an IOLTA account, just like any other bank account, there's interest. That goes to the Ohio Legal Assistance Foundation. It does not go to you, it doesn't go to your clients. All law firms, all attorneys must have some form of IOLTA account. You can't put tangible goods into a bank account, right? We're just talking about money for an IOLTA account. What do you do with tangible goods? Sometimes if you're doing estate law, if you've got a case over tangible property, you're going to be holding important documents, antiques, some tangible thing of value. 1.15 again tells us what we have to do. Property shall be identified as the client's property and appropriately safeguarded. What does that mean? The only guidance we have is from the comment, which refers to a safe deposit box. You can do a safe deposit box. If you have an office safe, you can do that. I would caution you, though, because when you're holding client property, just like when you're holding client money, you're responsible for it. If something happens to it, you're responsible. So if you have an office safe, you need to ask yourself, is it truly safe? And is it worth the risk? My law firm, we do, as Jen said, employment and civil rights law. It's not usual that we have tangible property of a client, so we don't keep an office safe. We don't keep I shouldn't tell you that, now you're all gonna come rob me. I don't keep any cash. Driver only carries $20. We don't have a safety deposit box. But if a situation arose where I need to keep some tangible thing, that's what I would do because it's the most secure. You go to the bank, you get a safe deposit box. It's just not worth the risk, okay? How do we open an IOLTA account? It's easy. You go to your bank. Most banks in Ohio participate in the IOLTA program. You tell them, I want to open an IOLTA account. It's not that complicated. You have to show some proof that you're entitled to open one, but it's easy. If you don't want to do that, you can go to the Ohio Lawyers Assistance Foundation website, the OLAF website. Website's in your materials, and you can open one there. There's instructions on how to open one. Once you open it, you got to register it with OLAF, okay? Again, because the interest goes to OLAF. All right. What about record keeping? We are going to talk a lot about record keeping today, unfortunately. I told you earlier, if you can only remember one thing, don't commingle. If you have room enough in your brain for two things, if you're not too tired, if you're not too bored, and you can remember a second thing, the second thing should be this. Keep accurate and thorough records. All the cases we're going to talk about today, they stem from poor record keeping in one way or another, all right? Keep accurate and thorough records of your client funds. Records of such account funds and other property shall be kept by the lawyer, 1.15a. This is a huge landmine. I can tell you from sitting on the grievance committee, this is a huge landmine. Almost invariably, when you see violations of 1.15, they involve poor record keeping, and almost invariably, they stem from poor record keeping. You'll see multiple violations that cascade off of each other, and almost always they stem, one way or another, from poor record keeping, all right? So keep good records. What records do we have to keep? Unfortunately, it's a lot. Again, we look at 1.15A, 1 through 5. You have to keep a copy of your fee agreement. It's got to be written, right? For any client on whose behalf funds are held, you have to keep a record of the client's name, the date, amount, and source of the funds, which is where the funds came from, the date, amount, payee, and purpose of any disbursement, which is where they went, and the current balance of the client, the particular client's account. So that's for each client. For the larger bank account in general, you have to keep a record of the name of the account, the date, amount, and client affected by each transaction, and the account balance. You also have to keep all the documents from the bank statements, deposit slips, canceled checks. I know that's a long list. Here's a simple way to remember it, okay? Everything. You have to keep everything, all the records, and you have to keep them organized. Keep accurate and thorough records. That is your other North Star. That's your South Star, okay? Keep everything, keep it organized. Let's look at a sample IOLTA ledger. This is the form that my law firm uses. You can do it any way that works for you. Excel spreadsheet, Word document, whatever works, as long as you have a system that is reliable, that captures everything, and that is consistent. You can get yourself in a lot of trouble if you start doing it in sort of an ad hoc way. So I know this looks confusing at first. It's not. Once you figure out what your system's going to be, it's going to be easy. But here's how we do it. So this is each box is a client. Here's a client. You'll see this is a closed case. The first entry is the retainer. This is a client who's paying by the hour, paid by check, $5,000 retainer. These are all fictional, obviously. The date of the payment, the fee earned is the next transaction, how it was withdrawn, electronic transfer, so there's going to be a bank record of it that we could prove if there was ever a dispute, the amount, the date. When you're withdrawing fees earned, I don't know if you talked about this earlier today or not. Did you talk about billing clients at all? No. All right. When you're billing clients, itemized records. Some clients will want it differently. Some won't allow block billing. They'll require that each task be separated out. Whatever it is, you work it out between you and your client. Keep accurate, contemporaneous time records. Send your bills to your clients timely. Best practice is probably to do it every month. Not everybody does that. But send them an itemized bill. Get them to sign off on it so there's no dispute. But this is the amount withdrawn, the date. Next transaction is KD. That's a court reporter. Their invoice number, our firm's check number, the amount, the date, replenished retainer by check, fee earned, again withdrawn, and lastly, when the case was over, refund of the remaining amount to the client. And you notice at the bottom, zero balance. God help you, you better have a zero balance on your IOLTA account when the case is over. Because if you don't, you have screwed up royally in some way or another. It can be fixable depending on the reason, but you got to keep accurate and thorough records so that when the case is over, you don't have like $2 left over or $1,200 left over and you have no idea why that money is still there, or worse yet, when God really help you, if it's a negative balance, then you're in a world of trouble, okay? This is why you have to keep accurate records, a consistent system. This is another example. This is a contingency fee case. Client's not paying anything up front. First entry is the check from the defendant, case settled. On that date for that amount, fee earned. I didn't get that money, by the way. I wish. Fee earned, how it was transferred, electronic transfer. Again, there's a record of how much it went, where it went, when it went, and the client's amount. Again, clearly there's going to be a zero balance there because there's only two transactions really. So that's an example. You can do it however you want. Be accurate, be consistent, be thorough. One more thing on contingency, since you guys may not have talked about this earlier. How many people will be working on contingency fee? In general, I'm not going to call on you. Raise your hands. Just a handful? Okay. That's the most sheepish hand raising I've ever seen. You're lawyers. You passed the bar. You're supposed to be alpha personalities, A-type. Okay. All right. If you're working on contingency, many people don't know this, but you are required by the ethical rules to have a settlement statement signed by your client before you withdraw your fee. Okay? Make sure you do this. It lays out how much came in to the client, what the client's portion is, what your portion is, what went to cost. It has to be signed by the client. It also has to be signed by you. All right? Typically what I do is send it by email with electronic signature. I think that's probably good enough. And then you get it back from the client side. So, all right, that's enough settlement statements. What do I do with the records? I have to keep all these records. I have to keep everything. What do I do with them? The rules tell us you have to keep them for 7 years. It sucks. It's the way it is, all right? You got to keep a lot of things for a long time as an attorney. It's part of the deal. Records shall be preserved for a period of 7 years after termination of the representation or the appropriate disbursement of funds or property, whichever comes first. 1.15a. So we talked about, God help you if you don't have the right balance. What are the sort of things that lead to that? Well, one of them is failing to do a monthly reconciliation of your IOLTA account. This is mandatory. The rules require you, 5A5 require you to do a monthly, every month, every 30 or 31 days, 12 times a year, all right, every month, monthly reconciliation of your IOLTA account. Again, this is one of those things that stinks. It's a pain, but you have to do it. You have to pay your mortgage every month. You have to do this every month. And in fact, if you don't do this every month, it's going to take you down a road where you're not going to be able to pay your mortgage. All right? And, I'm only half joking. All right? So at my firm, frankly, I have my paralegal do it because I know and trust her, and we're going to talk about overseeing staff later on. So it's not that you have to do it yourself, but someone that you trust, someone that you're willing to trust your ethical obligations to has to do it. It's got to be done every month. It's actually not that hard. You go online, you get a bank statement in the mail every month, or you go online, you print it out every month, And unless you are a tremendous volume business, maybe you have 10 transactions off your IOLTA a month. It's not that hard to match up the checks and make sure everything's right. So that's record keeping. What goes in and what comes out of your IOLTA account? Well, money for the client goes in promptly. A retainer, retainer goes in. Checks from other side for your client go in. They go in promptly. Equally important is what comes out. Besides money to the client, the only thing that ever comes out of your IOLTA account, ever, is are fees actually earned or expenses actually accrued. Nothing else. You can put your own funds into IOLTA, thereby violating the golden rule under one circumstance, and this is it: for the sole purpose of paying or obtaining a waiver of bank service charges, and only in the amount necessary for that purpose. 1.15b. It's the only exception to the golden rule of no commingling. The comments give us two examples. These are the only ones that exist: to pay per check or per deposit charges, or to cover standard monthly maintenance charges. So if you got a bank that charges you per check, per deposit, or monthly maintenance charge, you have to put in money from your operating account. And I should back up, by the way. I didn't say as a premise. You will have an IOLTA account, and then you'll have a separate bank account that is your firm's operating account. All right. So when I say operating account, that's what I mean, the other account. You put your money from the operating account to pay the per check or monthly maintenance fees. But honestly, if your bank is charging you monthly maintenance or per check fees for your IOLTA account, find a different bank. My bank does not charge that. I use Charter One. Okay. So you shouldn't even have to worry about this exception to the golden rule. You should apply the golden rule. There are no other exceptions other than two that are mentioned in the comment. You can't use personal money, operating account money, and you certainly cannot deduct from the client's money in IOLTA to pay check printing charges, overdraft if you bounce a check, stop payment fees, ATM teller fees, wire transfer fees. Anything else not specifically allowed has to be paid directly out of the operating account, not transferred in, not paid out of IOLTA, okay? Your best practice is to just avoid this issue and apply the golden rule. So now we're going to come to the most important, the biggest place for trouble aside from poor record keeping. And I'm going to reiterate it because it is so important. There are no circumstances, none, zero, never, ever, ever should you pay business or personal expenses from your IOLTA account, okay? How many exceptions are there to that rule? None. Zero. That's right. Thank you. At best, if you pay money out of your IOLTA account for business or personal expenses, it is considered commingling. At worst, it is theft. It is a crime. Either way, it's bad for you. The question is how bad, but either way, it's going to be really bad. This is a rule that we will see violated several times today. So I'm going to highlight it for you now so that you know how serious it is. Our next point is that you have to be prompt. When you're dealing with client funds, be prompt. If you have earned a fee and there's money in IOLTA to pay the fee, promptly transfer it to your operating account and then write the check from the operating account to yourself or to the utility company, to the phone company, whatever it is. If the fees are earned, they become yours. Leaving them in IOLTA is commingling. Promptly transfer them, take the long road. It's writing an extra check, it's doing an extra transfer electronically, but you must do it because there are no circumstances under which you can pay yourself or pay business expenses out of IOLTA. Transfer it to operating and then transfer it to whoever gets paid. No shortcuts. How else do we have to be prompt? When you receive funds that belong to a client or a third party, you have to promptly notify that person that you got them. This overlaps with our duty of due diligence under 1.3. A lawyer shall act with reasonable diligence and promptness in representing a client. I mentioned funds belonging to third parties. What do I mean by that? The comments tell us that when we're talking about third parties, that rule only applies when the lawyer has actual knowledge of a statutory lien, a final judgment addressing disposition of those particular funds or property, or a written agreement by the client guaranteeing payment from those specific funds or property. The typical examples are insurance subrogation, doctor's lien, Medicare, Medicaid lien, or a law firm or a case funding company. Are you guys familiar at all with case funding companies? In the PI bar and med-mal bar, cases can take tens of thousands up to 100,000 in costs to get to trial. Not everybody has that kind of money out of pocket, even law firms, to do it. So sometimes you will the client will enter into a contract with a case management funding company. They'll forward those costs in exchange for a chunk of the recovery. It's perfectly ethical. Supreme Court has said you're allowed to do it. So that's what we're talking about in terms of a written agreement by the client guaranteeing payment from specific funds. In terms of Medicare, Medicaid, you should be aware that if your client is on Medicare, Medicaid, and part of the damages in your case is recovery for his Medicare, Medicaid expenses, you have a statutory obligation to protect Medicaid's interests, which means promptly notifying when you receive those funds, okay? For that. So while you can be liable, as an aside here, practical tip, as an aside, while you can be liable for Medicare, Medicaid, in general, lawyers are not allowed to personally agree to indemnify any third party as a condition of settlement, or the defendant as a condition of settlement, okay? It would be unusual, but I have seen it happen in my practice where the other side will say something like, lawyer, Matt, you need to sign this agreement because we don't trust your client. You need to be responsible if your client breaches. Well, no, actually, I don't. And if my client breaches and doesn't pay, or my client breaches and owes something, advisory opinions 2011-1 tells us lawyers cannot personally agree to do that indemnification, no matter how little the defendant trusts the plaintiff. So plaintiff's lawyers are not allowed to agree to that. Defense lawyers are not allowed to ask for it, okay? How else do we have to be prompt? After you notify a client that you have the funds, you have to promptly deliver the funds to someone who's entitled to them. 1.15D. And if the person, the client or the third party who's entitled to them, asks for an accounting, you have to give a prompt accounting. What if there's a fight over the money? If there's a dispute over the funds that you're holding, the lawyer shall hold the funds or property until it's resolved. 1.15E. But don't be a hero, okay? You can represent your client's interests. What you can't do is unilaterally decide how to resolve the dispute. The comments tell us that, comment 4, all right? Promptly distribute all amounts that are not in dispute. Let's say there's $100,000 of settlement money. 75 is in dispute, 25 is not in dispute. You got to distribute the 25. You hold the 75 until the dispute is resolved. What if there's a dispute between you and your client, between the attorney and client? You can get in trouble here. Be very careful, document, do it in writing, so there's no question. A lawyer may not hold funds to coerce a client into accepting the lawyer's contention regarding fees. You can't have that phone call where you say, look, I'm holding this money. You know I'm entitled to it. What do you say, with a wink and a nod? Neither implicitly nor explicitly can you do anything that would remotely look like a threat. That's a good way to get yourself in trouble. And before you pick a fee dispute fight with your client, make sure your fee house is in order. Make sure that your fee is in writing, your fee agreement is in writing. Make sure it's ethical. Make sure it's reasonable and therefore ethical. Make sure it's not excessive. 1.5 guides us on what is a legal fee, all right? So before you pick a fight with your client, you should ask yourself about that, all right? Also, by the way, does anyone know what the statute of limitation, I feel terrible saying this, I should ask him to turn off the camera. anyone know what the statute of limitations on an attorney malpractice case is in Ohio? Yeah, that they teach you in law school. So the 1 year, yeah, 1 year from the close of the representation. Your malpractice carrier will ask you when you apply for insurance, do you wait at least 1 year from close of representation before suing a client for unpaid fees? I'm not going to comment on that question, but I'm going to tell you that you should read that question very carefully and consider why it would be asked by your malpractice insurance carrier, okay? So make sure your fee house is in order. That's the nuts and bolts, all right? Common mistakes and how we avoid them. We hinted at some of them. Here's a big mistake that we see on the grievance committee. Here's a big mistake that you see on the published cases, the discipline. The case get hit hard, where lawyers really get hit hard. Robbing Peter to pay Paul. You cannot borrow money from IOLTA to pay yourself, to pay the phone bill, to keep the lights on, to pay your office rent, even to pay other clients. Okay? That is called stealing. It's also called theft, and you go to jail for it. Again, not joking, you go to jail for that, okay? In addition to losing your license. Here's how it happens. The cases I've seen, here's how it happens. It's hard to manage a law practice, especially if you're a solo, if you're on the plaintiff side, small practice. It's hard. You got a lot of expenses, you got overhead, cases take a long time to settle, you get a little bit behind here or there. And then you settle a case. But you have bills to pay, so you borrow a little bit from the client's settlement, just a little bit here or there, and you pay yourself, or you pay the rent, or whatever. And you'll make it up to the client, because you're going to settle the next case pretty soon. And you'll pay the client from that settlement funds. And the second client, you'll catch up eventually. Eventually the brakes will start going your way, okay? You just had a run of bad luck. And one thing leads to another, and you've done it to 17 clients, all right? As I said, that's called theft. It's not only an ethical violation, it is a crime, and you will be prosecuted for it. So the grievance committee is the least of your concerns. When money comes in for client A, it belongs and gets distributed to client A or their lawful lien holder and to nobody else. Because if ODC, the disciplinary council, or Cleveland Bar Grievance Committee, or Supreme Court thinks that you are using client funds in some sort of Ponzi scheme, or worse yet, paying yourself and not paying your clients, you will lose your license and go to jail. Again, when fees are earned, and there's money on IOLTA to pay those fees, withdraw it promptly, and the only check that gets written for fees from IOLTA is to your operating account, not to Matt Besser directly, to Bolick Besser Iglesias operating account, and then from Bolick Besser Iglesias operating account to Matt Besser or whomever, all right? I know this is a lot of extra work and it seems nitpicky, but it just looks like theft if you're paying it from IOLTA. And at a minimum, it's commingling. So don't go down that road. Let's look at two recent examples. Case versus Dockery. And I did a Lexis search, and there's a lot of cases like these. I just pulled recent ones, okay? Disciplinary counsel versus Dockery, 2012. This lawyer was commingling funds in IOLTA for many years, used IOLTA to pay personal and business expenses, including rent, telephone bill, membership dues, family medical expenses, gave himself a $2,000 personal loan from IOLTA to cover a deficiency in his personal checking account, didn't keep IOLTA records for 3 years, didn't reconcile the account. He got 1 year, all of it stayed because of what I would describe as extremely good mitigation. Most people aren't going to have that luck or that mitigation. In a more recent case, the lawyer was not as lucky. Disciplinary counsel versus Thompson from this year, the lawyer used the client trust account, quote, as if it were his personal bank account and law office operating account. He used it for law office rent, for his personal rent, for credit card phone bills, didn't timely withdraw fees earned, didn't maintain his records, which led to 4 overdrafts. He got 24 months, 2 years with 18 months stayed. Again, he got sort of lucky. The point is here, robbing Peter to pay Paul causes where you're always catching up. You're always behind. And you just don't want to go down that road because your career may not survive it. I mean, not to be rhetorical about it, but your career may not survive that. Even if you don't lose your license, frankly, legal community is not that big. In Cleveland or Akron, wherever you're going to practice, it's not that big. And people know who's who, and people know who's been slapped by the Supreme Court. And I'm not going to send a referral to somebody who I know might steal from the client or who has sloppy practices and has been disciplined. And a lot of other lawyers are like that. Your business will dry up. So, all right. Next common mistake, how to get caught. This will not be a surprise to you, but it's poor record keeping. This really is the best way to find yourself in front of a disciplinary committee for violation of 1.15. Failing to do your monthly reconciliation and other sloppy record keeping means that it's pretty easy to bounce a check because you don't notice that, hey, I got a zero balance and I'm writing a check out of here. What happens when you bounce a check out of IOLTA? The Ohio Revised Code tells us, the depository institution shall notify the Office of Disciplinary Counsel or other entity designated by the Supreme Court on each occasion when a properly payable instrument is presented for payment from the account, the IOLTA account, and the account contains insufficient funds. When you bounce a check, the bank calls ODC. And ODC says, that's interesting, let me make a phone call. And ODC calls you and says, hi, give me all your records. And if you don't have them, you're in trouble. Or if you have them and they show something bad, you're going to be in trouble too. All right? So it leads to an audit, and it gets you in trouble. Okay? By the way, sometimes you get audited and it's not trouble. Sometimes you get audited because the bank screws up. We didn't have a full audit, but we have had it happen where the bank accidentally deposited something from IOLTA into operating when they shouldn't have, or vice versa. I forget which way it was, but they did it wrong, and we had to notify ODC and get a letter from the bank saying what happened, that it was the bank's error, and ODC looked at it and said fine. So it's not always going to be life or death if some technical violation happens. Okay. There are discrepancies that can happen that can be explained. The question is, are you acting in good faith? Is it a one-time thing? Has anybody heard? Is there malice? Okay. So poor record keeping can lead you down the slippery road of temptation where you find yourself behind. You have to rob Peter to pay Paul. Let's look at two more recent examples. Disciplinary counsel versus Alexander, 2012. This lawyer failed to keep a proper IOLTA ledger for several years, led to an overdraft, which led to a disciplinary counsel audit, which led to disciplinary counsel finding out that this person had been putting personal funds into IOLTA, had been writing checks from IOLTA for rent, car payments, medication, internet, and he got suspended for 6 months. Do you guys know you guys have all surely had ethics, right? So you know what happens when you're suspended from the practice of law, what you have to do. You have to notify all your clients that you have been suspended from the practice of law, which is kind of embarrassing. In addition to not getting any of the money from doing the work, you have to transfer it all to different lawyers. Also kind of, right? Okay. Notice, by the way, that the three cases we've talked about all have fairly common fact patterns: commingling, writing checks out of IOLTA for personal business, and poor record keeping. It's because all these things sort of cause each other and feed off each other and overlap, which means that since we can identify the common mistakes, there's no excuse for them, and they're easy to avoid. Let's look at one more case here, disciplinary counsel versus Freeman, 2008. This is a lawyer who failed to make appropriate accounting of client funds, commingled, had 14 overdraws in the span of 3 years, bounced 14 checks in 3 years. ODC came in and did an audit. In addition to all the other things they found, the lawyer did not cooperate with the disciplinary investigation. That is a separate disciplinary violation. In addition to being an aggravating factor, it is a separate violation. And that's one of the ones that really ticks the Supreme Court off. If you lie to the Supreme Court or to the grievance committee, it really ticks off the grievance committee too. If you lie or if you don't cooperate, Rule 8.1 provides a separate violation, in addition to that being an aggravating factor. So it's a double whammy. This lawyer had a pre-existing OLAP contract, which said that he should not be handling more than routine matters because of mental health treatment. He was in violation of the OLAP contract, another aggravating factor. He got suspended for 6 months. Subsequently, he was suspended indefinitely because when he got the notice of suspension from the Supreme Court, he said, "Thanks, I'm going to keep practicing anyway." And the Supreme Court didn't like that. I mentioned OLAP. Do you guys know what OLAP is? Ohio Lawyers Assistance Program. If you find yourself struggling, if it's too much, if it's getting too hard, and you develop a drinking problem, a drug problem, a mental health issue, depression, anxiety, gambling problem, and you think, not me, but the simple fact of the matter is lawyers are something like 3 or 4 times more likely than the general population to develop all those problems, mental health and substance abuse. If you find yourself in that situation, call OLAP. It's confidential. They will help you. The cynic in me would tell you that if you get accused of a grievance, the first place that many people do run is to OLAP because, frankly, a lot of times, not always, but a lot of times, unethical behavior violations of the rules are caused by mental health issues, caused by substance alcohol abuse issues. That can be a mitigating factor, and obviously they can help you, right? So OLAP is an incredibly good resource. All right, so that's poor record keeping. Another common mistake, how to avoid it. Again, being prompt. This is not your savings account. Withdraw your fees promptly when they are earned. I touched on this a minute ago, but when the fees are earned, they are your property. And if you leave them in, it's commingling, violates our golden rule. It's a red flag for the IRS because it looks like money laundering or tax evasion, and it looks like theft. Let's look at one more case today that's a good example. Akron Bar Association versus Tomer, 2013 case. Again, I just picked some recent cases. This is a former 16-year county prosecutor in Summit County. Started her own practice. She twice attempted to transfer more out of the account than she had deposited in it. Bounced checks. Used client funds to cover business or personal expenses such as cell phone, electric bill, department store. The bar found out she had overdrafted, requested the IOLTA records, did an audit, and they found out that she had been using IOLTA for personal funds. And she said, well, wait a minute, I'm not stealing, I just didn't withdraw them in time. I just didn't timely withdraw them, and I just wrote the check for my IOLTA. Ultimately, the bar agreed that that's what happened. She was not stealing, she was just not timely. She was just commingling. There were some other things going on in this case that makes it sort of an unusual case. There were about 4 other separate violations of the ethical rules. She had deposited a retainer into a business account rather than IOLTA. She failed to timely file a notice of appearance, and she didn't get the waiver from the client, notifying the client she wasn't carrying malpractice insurance. If you've been counting, we have commingling plus the 3 I just listed, that's 4. What's the 5th violation? The 5th violation is that when she got the notice of grievance from the Bar Association, she said, oh shit. And she went to Microsoft Word and she created backdated letters that purported to show that she had not neglected a client matter, that she was timely. AC looked at it and said, great, now all we need is proving that these are authentic documents. And the review of the metadata showed that she had created the backdated documents. That's a separate violation. It's actually 2 separate violations. 8.1, failing to cooperate in a disciplinary investigation, and 8.4, dishonesty, fraud, illegal behavior. So we have 5 or maybe 6 violations. Although the board did conclude that she wasn't stealing, she was just commingling. Who thinks that this lawyer is still practicing law? Somebody guess what they think they did to her. Anybody? Hammer come down hard or soft? Hammer came down soft. She got 2 years, all stayed. No act. You might have looked ahead. Did you look ahead in the materials? Just a guess. All right. Why did you guess soft?
She worked for the government.
I'm so shocked. Yeah. I mean, the fact of the matter is, if she had been a solo practitioner, if she had represented criminal defendants, just being cynical now, I don't know if the outcome is the same. She got 2 years, all stayed. I think for most lawyers, young lawyers, solo practitioners, if you got caught with this set of facts, you would not be practicing law. And I think this case is an anomaly, and I don't know this lawyer at all. And from what I understand, her reputation for those 16 years had been good, and she had been laid off from the prosecutor's office and was under stress, and the board said, fine. But man, do not find yourself as the respondent with that set of facts. So I don't think you'll get the same result. So, last common problem and how to avoid it is failing to oversee staff. This is not as common as the other ones, but it's still an important one. You are responsible for your non-attorney staff. If they don't follow the rules and they screw up, commit an ethical violation, you might be liable for that. 5.3 says that reasonable efforts to ensure compliance on lawyer staff. In addition to the ethical implications of this, consider the malpractice implications. If your paralegal, you send her to, or him, to go file a complaint on the day it's due, don't wait till the day a complaint is due if you can avoid it to file it, by the way. And forgets, loses it, goes drinking, whatever, and you blow the statute, that's on you. If your office staff is violating the rule on client fund management, that could be on you. So in addition to the grievance, you have to consider the malpractice implications. As a general practice tip, I would suggest that you also consider whether you want to give non-attorney staff check writing authority or access to your bank records. In my office, we don't. Even though my one non-attorney staff member is literally a member of my firm's family. She is literally related to my partner. And trust her with babysitting and all that. Just as a matter of practice, we don't do it. And the reason we don't do it is because there's a lawyer I know who practices on the plaintiff's side, and she had a staff member who worked for her for many years and was also considered effectively a member of the family. And one day they found out that something like $50,000 was missing. And it turns out that this non-attorney staff member who had access to the bank accounts, was basically the firm's CPA, had access to the bank records, check writing authority, had been skimming, had been embezzling off the top in numbers small enough that no one would notice, but big enough that it added up to a huge number. And eventually they found out, because where's all our money? And they filed charges and they sued her civilly, but that money is gone and they didn't get it back. So that's not to say that you can't trust people or you should go through the world cynical. You'll all become cynical from practicing law, especially if you're litigators. It's not too late, by the way. To go to med school, I mean. It's not too late to go to med school. You don't have to be cynical, but hope for the best and prepare for the worst. Have that safeguard, okay? Practice tip. The last common mistake is a future mistake. It's not one that I've really seen before, but it's one that I could anticipate happening. Attorneys can accept payment by credit card now, either for a retainer or for fees already earned. But you got to be real careful about the way you do it. If you're going to accept payment by credit card for fees actually earned, it should go into your operating account. If you're going to accept credit card payment for something that has to go into IOLTA, for a retainer, it has to go into IOLTA. There's an advisory opinion that talks about this, and it says that the preferred practice is to have two separate credit card and merchant accounts. One that goes into IOLTA, one that goes into your business account, and the appropriate fees go wherever they're supposed to go. If for whatever reason that's not feasible, here's how you do it. And if you do it backwards, you're going to get in trouble. You're going to have one merchant account. The payment has to go into IOLTA. And then if it's payment for fees already earned, immediately transfer it out of IOLTA to operating. not to yourself, not to utility company, because remember, there are no exceptions from when you can pay personal bills or yourself from IOLTA. So it goes into operating, and you got to do it promptly again, because it looks like commingling if you don't. You can't do it the other way. You can't have one that goes into your operating account, and if there's a retainer being paid, it goes to operating account, you transfer to IOLTA. All right. So you got to be careful if you're going to do that. My firm does not accept payment by credit cards, although I know a lot of plaintiff side firms that do. So just be careful if you're going to do that. What's going to happen if you screw one of these things up? I've thrown a lot at you. Remember, there's only two things you have to remember, really, right? Don't commingle, keep accurate records. And I guess the third would be don't steal. And maybe a fourth is you can never pay yourself out of IOLTA. 4 things, that's it. That's all you have to remember. All right, so what's going to happen if there's a screw up? As a practical matter, if your violation is technical, if it's minor, if it doesn't involve malice or greed, if it's a one-time thing, if your client isn't harmed, probably nothing, especially if you self-report. ODC doesn't want you to self-report if it's really nothing, if it's like just an oopsie, and you fix it right away and nobody's hurt. But if you self-report, you're on the side of caution, you self-report, and it's one of these minor things, probably nothing's going to happen to you. Maybe at worst, a private reprimand, public reprimand, state suspension. You're not going to be suspended, okay? It's when greed starts coming in. It's when clients get hurt. It's when there is long-standing patterns of recklessness or malice. That's when the hammer is going to come, and it is going to come down hard, despite some of the cases we've seen, despite some of the exceptions. That's when you're going to get yourself in trouble, all right? So that's generally it. 2 other side rules. 115F talks about how to handle IOLTA record keeping when a firm dissolves. 115G concerns how to handle IOLTA records when you sell a law practice. If you ever need them, that's where they are. If you have questions about how to handle these when you go out into your practice, there's an FAQ section on IOLTA on the OLAF website. I've included that for you. And if you have questions that aren't answered there, ODC will answer your questions because they don't want trouble. They don't want to come in and investigate. So you can ask a question of ODC beforehand. The number's in there. They're open 8 to 5. Any other questions? You guys can tell all your respective bosses that, boy, they kept us all day. They kept us till 5. Sorry, long weekend. If you have any questions, I'll be down here. Otherwise, thanks.